Cynthia Hegarty, and I'm an attorney at Winthrop and Weinstine in Minneapolis. I work in our creditors, remedies, bankruptcy, and workout group. I'm here today to talk about how you get a receiver appointed and the types of receiverships that are available under the Minnesota Receivership Statute. First, I'll point out that the Minnesota Receivership Statute is very robust compared to a lot of other states. My colleague Jeff Ansel was part of a committee that rewrote Minnesota's receivership statute in 2012. It's codified at Minnesota Statutes Chapter 576. My comments are really going to be solely related to Minnesota receiverships, although they may have application in other states depending on the language of the statutes there. So let's start with the premise that you or your client is a lender having provided a commercial loan to a borrower whose loan is in default, and assume that all requisite notices of default have been given. The issue now is how can the lender best protect its interest and obtain the fullest recovery? Receivership is one tool that can help accomplish that goal. While receivers are most often commenced by creditors, they're sometimes filed by a shareholder or a member of a debtor entity that has an outstanding loan due to them so that they become a creditor of the company. So the first step in the process is to initiate a lawsuit in the district court in any county in Minnesota. Those are courts of general jurisdiction. Commonly, these lawsuits are for breach of contract and are seeking foreclosure or replevin of lender's collateral. However, appointment of a receiver can also be sought in Minnesota as an independent cause of action, although that is not as common. Once the lawsuit has been initiated, the next step is to bring a motion for appointment of a receiver. First, I want to provide a tip. If you're representing a secured lender and you have a relatively good relationship with your borrower, I think it's always a good idea to have a conversation first to see if they're willing to stipulate to the appointment of a receiver. That can save both party time and money, and will give the borrower then a better feeling because they will have some input as to the identity of the receiver and to the terms of the receivership order. I'll give you an example. I had a recent case where the borrower and the creditor were just at loggerheads. The lender was refusing to allow the borrower to utilize reserves that had been set aside for certain tenant improvements to a building. Ultimately, the parties stipulated to the appointment of a receiver. And that caused the receiver then to reach to the lender and say, hey, I need you to advance funds so that we can make these improvements to make the property more attractive, to make it, get it leased up. And ultimately, the property was improved, new tenants were located, the borrower was able to sell the property at a higher price and pay the secured lender in full. It was a success story given how difficult the relationship was at the beginning. One warning to lenders in a receivership is that the lender who is commencing the action needs to be aware of the fact that if the property itself can't cash flow, the receiver is going to look to the lender to make loans to the receivership to advance funds to maintain the property. Those will be repaid on a priority basis, but as counsel, you'll need to get your client lender comfortable with the fact that they're going to be advancing funds, fronting a lot of those expenses and not getting paid until the end of the receivership when distribution is made. If a receivership cannot be accomplished by stipulation, a motion to appoint a receiver can be done with notice to the borrower and other parties in interest. In Minnesota, the appointment of a general receiver is treated as a dispositive motion, and it must be served at least 28 days in advance of the hearing. A motion to appoint a receiver can also be done on an ex parte basis, where the court may enter an order appointing a temporary receiver pending a hearing after appropriate notice on the merits of the motion. This occurs in an emergency situation, generally where the initiating creditor can demonstrate some type of irreparable harm in the absence of immediate action by the court. I've obtained emergency relief on behalf of lenders where the borrower is engaged in fraud, has misappropriated rents, has allowed significant waste to occur to the property, or refuses to remediate damage, and is then impairing the value of the lender's collateral. The motion for appointment of a receiver should include really 5 elements: grounds for the appointment of a receiver, the type of receivership being requested, a description of the property over which the receiver is being appointed, the identity of the proposed receiver and his credentials, and the powers and duties to be conferred upon the receiver. Of critical importance is developing a proposed receivership order, and that'll be discussed in a separate video in this series. If the receivership order does not describe the receivership property, the receiver will be deemed to have control over all of the respondent's non-exempt property. In Minnesota, the state district courts have exclusive authority to appoint a receiver, direct the receiver, prescribe the receiver's powers and duties, and as well as authority over all receivership property, which includes disputes regarding collection, preservation, improvement, disposition, and ultimately distribution of receivership property. I can't implore enough, one of the most critical things you can do as counsel for the creditor or for the receiver at the outset of a case is to learn the judge's background in advance. It's been my experience that many state court judges are not familiar with receivership proceedings, and they sort of view them like federal district court judges do when they get a bankruptcy appeal. You're going to get a judge who's got a criminal background or a family law background, and this is just not something that's familiar. So take the time to educate the judge about the parties' relationship, the factual basis giving rise to the need for a receiver, and then let the judge understand how receivership works. Explain that the receiver is employed by the court, takes direction from the court, reports to the court, and that the receiver is a neutral party, disinterested in the outcome, but is there to transparently preserve and protect assets, or in a general receivership, to diligently market and sell assets for the benefit of creditors. Now in Minnesota, we have two different types of receiverships. We have a limited receivership and a general receivership, and we'll talk about the differences now. If the receivership order does not specify the type of receivership that it is, it will be deemed to be a limited receivership. Limited receivers are appointed over specific assets. This occurs frequently where the creditor's action is based upon enforcement of an assignment of leases and rents, or the foreclosure of a mortgage lien, a judgment lien, a mechanics lien, any type of lien where the debtor has a statutory right of redemption. Under these circumstances, it's rare for a receiver to have authority to sell property that secures a lender's loan because the courts are mindful of the borrower's right of redemption and wants to respect that. So the receiver steps in and then preserves and protects the property during the pendency of some other process, like a foreclosure. General receiverships, on the other hand, are given control over all of the debtor's assets and operations, and they generally step into the shoes of the chief executives of the company. They're appointed sometimes to liquidate a business, to distribute the proceeds to creditors in a statutory order of priority, all with court approval. And most importantly, a general receiver has kind of a special tool that allows them the power of sale of receivership property free and clear of liens, similar to a 363 sale in bankruptcy. The receivership sale is not a foreclosure, and therefore the receiver sells the property free from rights of redemption. Both limited and general receivers incur and pay expenses in connection with the receivership, control, manage, and preserve receivership property, which includes the right to lease real estate, to assert rights, claims, and defenses to receivership property. However, only general receivers may pursue claims under the Avoidable Transactions Act, operate the business as a going concern in the ordinary course of business, and to sell receivership property if authorized by the court. In the motion to appoint a receiver, you're going to need to specify the grounds for the appointment of a receiver. And those grounds can be dependent on different circumstances in the case and based on the procedural posture of the proceedings. A limited receiver can be appointed before judgment to protect a creditor's interest by demonstrating that the property or its rents and profits are in danger of loss or material impairment. We often see that where the creditor is commencing a foreclosure action and wants a receiver appointed during the pendency of that action because the borrower is failing to pay taxes, failing to maintain the property, committing waste at the property. As an example, I had a recent case representing a lender where the borrower's real property sustained significant water damage during the winter. It wasn't reported to the lender. The lender learned through a third party about this extensive water damage and then went to inspect and discovered that the borrower wasn't taking adequate measures to maintain the property, and this led to significant waste and damage. So a limited receiver was put into place. A limited or general receiver may also be appointed as part of a judgment or after a judgment to carry the judgment into effect, to preserve the property pending an appeal, or when an execution has been returned unsatisfied and the judgment debtor refuses to apply the property in satisfaction of the judgment. And then finally, receivers are also appointed when a corporation or other business entity is dissolved, insolvent, or in imminent danger of insolvency. I recently represented a lender, had advanced a series of loans and different credit facilities to a borrower who operated several fast food restaurants that were franchised. The businesses were mismanaged, they were not profitable, they were not in good standing with the franchisor. And as a result, the lender had a concern that the owner was also using corporate funds for personal use. Ultimately, a general receiver was appointed on an ex parte basis, and all of the assets ended up being sold by the receiver and applied to the debt of the secured lender. There are some special rules for appointment of a receiver over mortgaged property, which can occur at any time during the commencement of foreclosure proceedings and before the end of the borrower's redemption period. If one, the mortgage is being foreclosed, has a loan of over $100,000, or is a lien on residential real estate consisting of more than 4 units, and is not a lien upon homestead or upon agricultural property. And what's interesting in this case is the court must appoint a receiver upon the request of the lender if the borrower mortgagor has breached a covenant in the mortgage relating to misapplication of tenant security deposits, failure to pay real estate taxes or special assessments or to escrow for the same, and failure to pay insurance premiums. Receivers are also appointed in other types of cases, most notably those involving fraud. Many of you will recall that there was a receiver appointed over the Tom Petter's personal assets after his Ponzi scheme had been uncovered. The receiver put his corporate entities into bankruptcy, but continued to manage and liquidate Tom Petter's personal assets through a receivership. If you've got any questions regarding receivership in Minnesota, I would be happy to speak with you and share my experiences. Please reach out. Thank you.